is Pablo DeJesus. I'm the Executive Director of Unitarian Universalists for Social Justice. Thank you so much for joining us this evening. We're delighted to have Brie Sparkman speaking with us this evening. And I see that we have several of UUSJ's trustees on this call, including Reverend Latifah Griffin, who will be opening a sacred space for us this evening. I just want to thank everyone for joining us this evening. I've heard from so many of you that we're worried as Unitarian Universalists about the state of our democracy. And certainly this past 6 months or so, the conversation around the Supreme Court has been elevated. And so we're delighted to have our guest speaker this evening share with us some important information about relevant legislation and perhaps some thoughts on the issues at play when we're talking about the US Supreme Court and ethics reform. I want to thank all the wonderful members of the Democracy Action team who have put together this event and materials related to what UUSJ is doing on this issue. I want to invite folks to pay close attention to our September e-news when we're going to be giving further details about a variety of opportunities, not least of which will be mention of something we're calling Power Sunday. We're going to be asking congregations across the United States to preach on a topic, sort of in concert and together in unison. So we'll have more details for you at a later time on that. And I want everyone to know, especially those within driving distance of Washington, D.C., that in late September, UUSJ will be participating in a UU conference, joint conference with several other organizations around issues of the Farm Bill. So if you happen to be within driving distance or within train distance and want to join in fellowship with other Unitarian Universalists and learn some more about the Farm Bill and then do some advocacy on that, you're invited to respond to our materials when we put them out. But with that, I want to turn the spotlight over to the delightful Reverend Latifah Griffin, who hails to us from Florida. With that, Reverend Latifah, please open a sacred space for us.
Thank you. Good evening, folks. I will start with a description of who I am. I am a middle-aged Black woman who identifies as she, her. I have long Black hair and dark brown skin. I also have a purple chalice next to me, and I am located in Palm Beach, Florida, on the land of the Yega and the Seminole Nations. As we begin our time together, let us take a moment to find our breath and to identify our intentions for being here this evening and to remember why. Thank you. Ethics, no matter who you are, what you believe, there is a matter of personal and professional ethics that everyone has or should espouse to have. My prayer for everyone present this evening and everyone that we are connected to, may we find it in our personal and professional ethics to speak up, to empower, and to act courageous towards acts of injustice. Now I invite you, with these words from the Reverend Nathan Ryan, to join with me in lighting our chalice if you have one nearby. And the words are titled, A Renewed Hope for This World. Be it real or metaphor, whatever is in your backpack or briefcase or your purse that you've brought into this space this evening, leave it behind. Whatever you carry that is keeping you distracted or caught up in shame or guilt or hopelessness, leave it behind. And if you need it, it will be there when we're done. But for this 1 hour, just let it go. Come into this place with open hearts. Come into this place with a soul that has remembered how to be tender again. Come into this place renewed, for hope for this world and come into this place ready to build a new world that we've always been worthy of and always dreamed of. Let us now open this sacred space.
Thank you so much, Reverend Latifah. We're delighted to have you on our board. And I see Sandra Wilmore, who's also a member of our board. Maybe you can raise your hand, Sandra. And I think I saw Dan. Maybe Dan Schneider, you can raise your hand. There may be others who are members of our board and past members of our board. I know I saw our previous board chair, Charlotte, join the call. So I just want to take a moment and thank all of the folks who do deep volunteerism with UUSJ, both the teams and the board members. So often I encounter folks who think that our organization is much larger than it is. And that's because of all the wonderful work that folks like you in this room put in. And it's a result of the expertise with which our volunteers speak about the issues because of sessions like this. And so this evening, we're delighted to have Brie Sparkman, who currently serves as Citizens for Responsibility and Ethics Policy Counsel. I should mention that I, at least, and I think others in UUSJ count CREW as one of our very friendly organizations. We've had CREW presenters in the past, and they've always delivered wonderful content for us. Prior to joining CREW, Brie served in various roles in the U.S. House of Representatives, most notably as the legislative counsel to Representative Henry C. Hank Johnson Jr., then chairman of the House Judiciary Committee's Subcommittee on Courts, Intellectual Property, and the Internet. So Brie is well positioned to speak about some of these issues. Brie received her JD, magna cum laude, from the University of San Diego and her BA from the University of California at Santa Cruz. And hopefully you've noticed in our promotions for this event, we just want to celebrate. Brie is a lifelong UU out of California. I, as a New Yorker, won't hold that against her, but you know, let's let our hair down a little bit and celebrate that we're in community. It's not often that we get to speak with policy experts who are also UUs. So let's pay special attention to Brie, and let's learn some more this evening about the Supreme Court and the ethics reform that we would like to see happen. And with that, we're going to spotlight Brie.
Thank you. So as Pablo said, my name is Brie Sparkman. I am currently policy counsel at Citizens for Responsibility and Ethics in Washington. We are located here in Washington, D.C., so that's where I am coming to you from. As Pablo also said, prior to CREW, I spent several years in Congress as Congressman Hank Johnson's Judiciary Counsel. So I've spent a great deal of my career thinking about Supreme Court ethics. And I was also raised in the Unitarian Universalists Fellowship of Stanislaus County, which was a mouthful when I was a kid, but that's out in California. And so for many reasons, I'm happy to be here today. I am going to speak at you for about 15 minutes. I don't have any slides or anything. I'm old school in that way. So, and then I'm happy to take questions after. So as a brief overview, a constant refrain that we hear lately is that the 9 justices of the Supreme Court are the only federal judicial officers in the nation not subject to a code of ethics. And this is entirely true. As a bit of background, all other federal judges, and in fact judges in the United States, abide by what is known as, well, for federal judges, the Code of Conduct for United States judges. This code was officially created in 1972 in response to an ethics scandal involving Justice Fortas of the Supreme Court. And the code was officially applied to federal judges in 1973. This code has since gone through several different revisions. It currently has 5 ethical canons, which govern issues like recusal, judicial integrity, impartiality. It outlines permissible extrajudicial activities for the judges, and it also provides federal judges with guidance on how to perform their official duties. So this code of conduct, as I've alluded to, has never been applied to the Supreme Court, despite the fact that it was a Supreme Court justice's own ethical scandal that led to the federal adoption of this code of conduct in the first place. And in reality, every major ethical reform for the judicial branch as a whole has been born out of some sort of scandal. So I and CREW believe that we are at such inflection point today. Because the judiciary itself is built on a foundation of public trust. Without the power of the purse, like the legislative branch has, or the authority to enforce laws that it interprets, like the executive branch, its credibility is its currency. And we can see pretty clearly that this credibility is eroding and has been arguably for quite a long time. Over the past several years, though, the court has subjected the American people to scandal after scandal, leading the public's confidence in the judiciary to plummet. These troubling incidences, I'd maintain, were preventable, if not entirely predictable, given the court's lax ethics and recusal systems. The Supreme Court's judicial ethics regime, as it currently is a mishmash of vague and inadequate rules, loose self-monitoring. Some might say that the system has failed us. I'd argue that it was designed not to succeed. So despite recent scandals, the Supreme Court has failed to heed the calls of the people and adopt its own binding code of conduct thus far. The Chief Justice himself has made clear that the justices consult a wide variety of authorities. He points to judicial opinions, scholarly articles, treatises, historic practices of the court, disciplinary decisions stemming from the AO. But again, none of these sources of, quote, guidance, as he calls them, have binding authority over a justice's decision, which the Chief Justice also makes clear. So Supreme Court justices are afforded an immense responsibility of passing final judgment on matters of life and death, educational equity, voting access, reproductive health, separation of powers, the rule of law. The list goes on, and almost all of which I just mentioned, we saw came before the court in this last term. In addition, Supreme Court justices enjoy the privilege, the unique privilege of lifetime tenure. So in return for this, it's certainly reasonable to demand that the men and women of the Supreme Court uphold the highest principles of ethics and accountability. And yet they're seemingly unwilling to do so. And this speaks to, in a way, the arrogance on the part of the justices, as well as negligence from the other branches, despite unprecedented ethical scandals. So I want to talk a little about like what's the problem here. In theory, the Supreme Court is subject to several federal statutes. There's the federal disqualification statute that governs when and if they should recuse, as well as other statutes like the Ethics in Government Act and the Ethics Reform Act, to name a few. But these statutes are largely devoid of any enforcement mechanism as it pertains to this nation's highest court. So in practice, this results in a major, as we've seen, institutional problem. As we get inconsistent decisions on recusal by the justices, if we even hear if they've decided to recuse or not at all, because they don't have to. Too often, this results in conduct that causes the public to question the justice's impartiality, which is really the root of all of this. Over the past couple of years alone, the High Court has experienced a series of scandals that have tarnished our faith in the institution. So recent reporting, as I'm sure everyone on this call is aware, has revealed that both Justice Thomas and Alito accepted gifts of travel from billionaire political benefactors without disclosing the gifts, which is the key part. This disclosure is required by law. But to be clear, both liberal and conservative justices have routinely and too often publicly engaged in ethical misconduct. In fact, every Supreme Court justice, with the exception of one, Justice Souter, in the 21st century has had some sort of ethical lapse. And this truly is just a stunning indictment of our judiciary's broken ethical system, and a monumental problem for the institution as a whole, whose entire existence is premised upon a foundation of public trust. We've seen this play out in real time, as I'm sure there's the often cited statistic that the Supreme Court, the faith in the Supreme Court is at its lowest level since Gallup began polling the issue in 1975. So in light of all that background, I want to briefly touch a bit more on some of the recent scandals at our nation's apex court, as they really, in their own unique way for each one, highlight the need for a code of conduct that actually binds the Supreme Court. So there's Justice Ginsburg, who repeatedly heard cases involving her husband's law firm, including cases involving her husband's client, Ross Perot, and Perot's company, even though Perot helped organize support for her own confirmation to the DC Circuit. There's Justice Breyer, who twice failed to recuse from cases in which he owned stock in one of the parties. Chief Justice Roberts, Justice Gorsuch, and Justice Jackson all appear to have participated in cases in which they owned stock and otherwise had a material financial interest in the case. Justice Barrett refused to recuse from a case involving Americans for Prosperity Foundation, despite the fact that its sister organization spent, I believe it was $1 million supporting her nomination and confirmation to the Supreme Court. Justice Sotomayor chose not to recuse from a case involving her book publisher, despite having earned close to $2 million in royalty from the publisher since she joined the court. Justice Kavanaugh chose to participate in a case involving Facebook, despite his close friendship with a high-level executive there, who also happened to spearhead his nomination to the court. And Justice Kagan failed to recuse from a case in which she previously helped litigate it in an earlier version when she was Solicitor General. And this issue of failing to recuse when a justice or a federal judge has a material financial interest, this is a problem that has plagued the entire federal judiciary, not just the Supreme Court. This was born out of reporting by the Wall Street Journal in 2021. That bombshell reporting demonstrated that over just a 9-year period, more than 130 federal judges, so this excludes Supreme Court justices, presided over more than 650 cases in which they had a material financial interest in one of the parties to the case. So to put this number in perspective, 130 federal judges presided over these cases when they likely should not have. And there are only a total of 870 federal judges on the federal bench. So at least 130 of them failed to recuse where their impartiality could reasonably be questioned, which is the standard under the recusal statute. And while this reporting is shocking, it did not occur in a vacuum, and it's just another manifestation of these ethical issues that are undermining the Supreme Court and, in fact, the entire federal judiciary. And of course, we're all familiar, I think, at this point with Justice Thomas and his failure to recuse from several Supreme Court cases at this point, some relating to the 2020 election, despite his wife's problematic involvement, as well as recent reports showing his repeated failure to disclose hundreds of thousands of dollars in gifts and travel from Harlan Crow, the payment of private school tuition for his grandnephew, an undisclosed real estate deal, possibly an expensive RV. The list goes on and continues to grow. Justice Alito has also had a similar issue that just came to light when, in fact, it happened, I believe, in 2008. But he also accepted lavish gifts from billionaire Paul Singer, failed to declare those gifts on his personal financial disclosure forms and as required by law. And then he failed to recuse when Singer then had business in front of the court. So each of these incidences, from Justice Thomas and Alito to Justice Thomas and Justice Ginsburg's willingness to hear cases that implicated their spouses' activities, to Chief Justice Roberts and Justice Breyer's failure to recuse from cases in which they had a financial interest, So while not all of these are on equal footing, I'll make that clear. They do all show why the Supreme Court needs a binding code of conduct, and why a transparent and impartial recusal process must be a key part of that endeavor. Justice Thomas's pattern, I do want to make clear, his pattern of conduct is on an entirely different level of seriousness than many of his colleagues, both liberal and conservative, and may require different consequences after full investigation. But the issues each of these justices have run into makes it clear that the need for significant reform in the court's ethics regime must happen soon, now, preferably. So right now, the Supreme Court's recusal process in particular, such as it exists, is opaque and guided entirely, completely by the justice's own individual sentiment. The court's recent statement on ethical principles and practices, which the Chief Justice sent to the Senate Judiciary Committee, explained to the Senate Judiciary that individual justices, rather than the court, decide recusal issues. And in doing so, they are guided by a so-called duty to sit, which, according to the court's interpretation, precludes withdrawal from a case as a matter of convenience or simply to avoid controversy. So this is how the Chief Justice describes this duty to sit in this recent letter. This duty to sit, as such, produces seemingly random and contradictory results, leading the public to question whether the justices are able to effectively police their own behavior. We at CREW believe that this emphasis on the duty to sit is entirely misplaced. From the perspective of public trust and confidence, it's more important to have an ethical court than a fully constituted one. In fact, if there is such a duty to sit, the court should welcome a formal code of conduct. It provide the justice with concrete rules and guidance on how to engage with their official duties as well as their everyday lives. And this would thereby limit the need for recusals by providing the justices with this framework and helping them to order their lives and professional engagements and therefore avoid the situations that do require their recusal in the first place. So this argument by the Chief Justice just is pretty hollow. But as we all know, thus far, the Supreme Court has failed to take any meaningful action. So Congress can, which is key, and must step in. Because although the justices may interpret the law, they are not above it. So there are no shortages of proposals in Congress. It is certainly, the sexy issue of the moment, and there are quite a few bills. Largely, I'm here to talk about today about the Supreme Court Ethics, Recusal, and Transparency Act, also known as the SCERT Act, which has been introduced for the past 2 Congresses by my former boss, Congressman Hank Johnson, and the companion in the Senate is introduced each Congress by Senator Whitehouse. So the SCERT Act is a bill that I was fortunate enough to be able to take part in drafting. So by way of background, if it's helpful, we drafted this bill not to be a set of ideal ethical proposals, but rather to be a measured response to the scandals that we were seeing at the time when we first drafted it. And largely those scandals are very similar to the ones we see today. And it's more than that, we drafted it as one that could be potentially palatable to the court itself. So it was seen sort of as a compromise piece of legislation that we hoped would get bipartisan support. Thus far, I don't think they've been successful in that. But by building in these modest ethical guardrails into a system that lacks any was really our intent, and to see it kind of as a good first step. So the reforms included in the SCERT Act would require the Supreme Court itself to adopt a code of conduct, which is different than Congress itself imposing a code of conduct on the Supreme Court, tighter recusal rules, the creation of an ethical body that would provide guidance. It would help evaluate recusal decisions. The text would also mandate rules requiring disclosure of gifts, travel, and income received by justices, that are at least as rigorous as the House and the Senate disclosure rules. As it currently stands, they do not have as rigorous of rules as Congress. I also want to note that we believe here at CREW that the SCERT's recusal regime in particular, we find that it thoughtfully balances the importance of protecting the integrity of the Supreme Court's decision-making with the complexities, which I've briefly touched previously, but happy to chat more about, of the court's unique composition and structure. We have to recognize that asking a justice to recuse from a case is fundamentally different than asking a district court judge, for example, to recuse. The Chief Justice has correctly noted that lower court judges can freely substitute for one another, but the Supreme Court consists of 9 members who always sit together. They always sit en banc. And if a justice withdraws from a case, the court has to sit without its full membership. But as I've said previously, and I'll say again, a fully constituted court must yield to a fully ethical court. And really, when questions about the court's impartiality are at issue, recusal should be the justice's default position rather than the exception. We at CREW believe that one noteworthy and significant way to avoid these recusal questions is to take significant prophylactic measures to avoid the conflicts in the first place. So the structures proposed by the SCERT Act more than compensate for this worry that the court may not sit with a fully constituted court, which is what apparently keeps the Chief Justice up at night. And these enhanced recusal requirements under such code might disable the court and undercut its role in the constitutional structure. That's just not true. And there are several, as I said, other bills addressing the Supreme Court ethics crisis that are floating around Congress. There's Senator Warren's Judicial Ethics and Anti-Corruption Act, which is 58 pages long, so I'm not going to go into the details of that bill, other than to just say it is a very robust judicial ethics bill that would fundamentally change the way the judiciary conducts itself and presents itself to the public. I always call Warren's bill a liberal dream. So unfortunately, as you can imagine, it has no hope in passing Congress anytime in the future, or in the near future at least. There's also a bipartisan bill in the Senate. By bipartisan, it means one is a Republican, the other is an independent, but I do believe they have a Democrat or two on it as a sponsor. But this bill is known as the Kane-Murkowski bill, and it's a fairly simple text, and it just requires the Supreme Court to create its own code of conduct. And it also, I believe, appoints an ethics official for the court to review kind of potential conflicts of interest and provide some advice to the justices to help them comply with their ethical duties. CREW specifically believes that an inspector general for the judiciary would also go a long way in restoring public confidence. We've been working with the Senate, a few senators, to create a bill that would do just that. So an IG situated within, for example, the office of the administrative office of the courts would promptly be able to investigate any allegations of improper influence on judges and justices. This sort of independent oversight is needed, as we know, and there is actually longstanding bipartisan support for this type of reform up until recently, at least. And the judiciary, it's important to note, is currently the only branch of the federal government without an inspector general, which probably comes as no surprise. And then finally, just today, CREW actually published a new report in partnership with the Berkeley Judicial Institute at Berkeley Law, which is headed by Judge Jeremy Fogel, who's a retired district court judge in California. And this report explores the history of the Supreme Court's judicial codes and its recusal rules. Within this report, we actually propose a new recusal process to bolster accountability and trust in the court. Our proposal, similar to the SCERT Act, surprise, I also wrote this one, is designed to be a compromise solution, which seeks to chart a path forward that we believe would be more politically palatable for the justices themselves, while still addressing some of the most pressing and egregious ethical issues. We understand not everyone may love it. We don't love it. We view it as a compromise. Many may think it doesn't go far enough. Some are going to think, it goes too far. But our hope is that it would begin a dialogue on what a first step for accountability in the Supreme Court could, what it could actually look like. And then there are other court reform generally proposals as well. I think everyone's familiar with the Judiciary Act, which proposes to add 4 justices to the Supreme Court. There's a proposal for term limits. And then there's one that I particularly like to highlight for people, because I think a lot of people don't realize how big of an issue it is. That's the Judiciary Accountability Act. Also, introduced by my former boss, Congressman Hank Johnson, but it is led by Senator Hirono in the Senate. And the Judiciary Accountability Act would extend civil rights protections to over 30,000 judiciary workers who are not currently subject to civil rights protections. So, I mean, that's just, to me, that's 30,000 people in the federal government who are not protected by the federal civil rights statutes that prohibit discrimination based on race, color, religion, sex, national origin, age, disability. So this bill would seek to change that. And this, this fact seems shocking to a lot of people when I bring it up, but the fact of the matter is this was also the case for Congress until 2018. We didn't receive protection under federal civil rights protections until then. So before I close, I do want to make something clear. So while Justice Thomas's relationship with Harlan Crow, among other billionaire benefactors at this point, and his failure to disclose more than 2 decades of private luxury vacations and real estate transactions, possibly in violation of the Ethics in Government Act, well, they constitute egregious misconduct. There's no doubt about that. But I think it's important to note that Justice Thomas's scandals did not occur in isolation, and so they cannot be addressed as such. Justice Thomas, if anything, is a predictable result of the court's ethics crisis. He's certainly not the cause. He's not the reason this nation's highest court has the lowest bar for ethical compliance and accountability. This is a result of decades of benign neglect and wholly an absence of accountability. The fact of the matter is that the 9 justices of the Supreme Court should set the standard for ethical conduct. But instead, we currently have a court that acts as though it's above our democracy rather than a part of it. The Chief Justice has made clear that he cares deeply about the integrity of the institution, and I believe him when he says that. And that's why CREW continues to encourage him, together with the rest of the court, to adopt a binding code of ethics to actually seriously address these issues that they're facing. And if they do not, Congress can, should, and must act. So thank you.
Thank you so much, Brie. We deeply appreciate that robust and in-depth briefing. I myself have learned quite a bit about the bills that I'm embarrassed to say I didn't know were out there. So some of those were new to me, as I'm sure this information is new to many folks on the call. So this evening, I want to invite a member of our Democracy Action Team, David Shilton, to sort of lead off with a question that's been of interest to our Democracy Action Team, and then invite others to ask their questions. I'll just invite folks, to be brave and ask your question on video. We are recording this, and we know that it's always a better recording after the fact if you ask your own question. But with that, let's spotlight David and get to the Q&A.
Thanks, Pablo. Brie, this has been so helpful. Really appreciate it. We think the SCERT bill, glad to know that you drafted that, is excellent. But there seems to be a fair amount of pessimism about its path forward. Do you want to comment on what that path forward is? And I was just wondering if it is blocked, doesn't make it through. Is there a chance that the bipartisan bill, the King-Murkowski bill, even though it's weaker in many respects, might have a chance this session?
Yeah, I mean, as you point out, its weakness might actually be its strength in this Congress, given the slim majority that Democrats have in the Senate. But of course, it takes 2 houses of Congress to pass a bill. So if a bill were to pass both houses, it would likely have to be that bill. I don't even think that bill has a chance. But for the SCERT Act, so the way that it has proceeded through the House thus far is it has gone through what's called a markup in the Senate Judiciary Committee, which is the chance for members to add amendments to the bill. It's their first chance anyways. So it passed favorably out of the Senate Judiciary Committee, which now means it can come to the Senate for a floor vote. But as you correctly point out, the politics surrounding a floor vote on this bill are pretty precarious. At this point, it's my understanding from the Senate Majority Leader, they do not have the 60 votes needed to overcome a filibuster at this point. It's unclear if they even have, I believe they have all 50 votes of the Democrats, but that's still unclear, but they do need 60 to overcome that threshold. So unfortunately, as of now, it doesn't seem to be. That being said, both Chairman Durbin of the Senate Judiciary Committee and again, the Majority Leader have both said that this is a priority for them. And I know they've done a lot of behind the scenes whipping on this bill and others, and they would actually hope to bring not just this bill, but several others to the floor. So we'll see, but the House is led by 4 votes, with Republicans, and it's unclear that they would bring any sort of bill from the Senate to the floor. So it just doesn't look great, the prospects. That being said, I continue to urge y'all to continue to have meetings on these bills and this issue, particularly with members in the center, because that does always help hearing from constituents.
Great, thanks. That's very helpful. I was really kind of surprised, although not surprised in a way, to see Justice Alito's comments in the Wall Street Journal about allegedly Congress having no power to do these things. And I noticed it looks like Michael Thorne has raised a very similar issue. Michael, are you there? You want to ask your question on that?
I just wanted to make sure that if the Congress passes a bill, does the Supreme Court have to comply with that, or can they say the bill doesn't apply to us?
Yeah, I mean, it's a good question, and it's certainly one that constitutional scholars were constantly debating. That being said, the Constitution is pretty clear, and there are quite a few examples in history of Congress passing bills that govern the Supreme Court and them abiding by it. So, Congress's tradition stemming from the Constitution of regulating the conduct of Supreme Court justices stretches back almost to the beginning of the Republic. There was the Judiciary Act in 1789, which set out the judicial oath for justices. Speaking specifically to what you said, David, about Justice Alito's comments, I always find them a little disingenuous, considering his own position on the court was created by the powers vested in Congress. He himself, his position is not in the Constitution. The Constitution only creates a Chief Justice. So that right there says it all for me, but I will go through a few more statutes which apply to the Supreme Court currently that have never been challenged. So there was, of course, the Judiciary Act, as I said. And then specifically, I guess, of course, all of this emanates from Article 1 and Article 3 powers, but Congress has considerable control over the Supreme Court's structure and jurisdiction. Congress has the authority to raise justices' salaries, remove justices via impeachment. Congress has changed the size of the court 7 times by statute, and has created, as I said, this position of Associate Justice. So again, Justice Alito would not have a position but for Congress. So Congress in the past has exercised specifically constitutional authority to regulate Supreme Court justices' professional conduct through the nation's criminal laws. Justices cannot condition any of their actions on receipt of a gift. Justices cannot, what else can they not do? Many of the laws in the SCERT Act itself, as we were talking about, that the SCERT Act seeks to expand. So Section 455, which governs recusals. There's the Ethics in Government Act and the Ethics Reform Act. They've all been operative on the Supreme Court for more than a half a century, and the Supreme Court has abided by them. So to say that imposing any such reforms would be unconstitutional is disingenuous and just really not compatible with the operation of our Constitution and separation of powers. The Supreme Court may be, a creature of the Constitution, but that same Constitution that creates the court also gave legislative power to provide a check on that, on checks and balances. So we would just push back against the fact that there is no constitutional authority for Congress to regulate the court.
Yeah, I see that Andy Puchik, I hope I got that right, has a question, which is, how did the Supreme Court get hired for life? The other branches of government have to be elected for specific terms. What's special about being a federal judge?
Oh, that is a lot of history. I guess I'll just say it's in the Constitution, first and foremost. But the idea behind it was to insulate them from the political whims of the people, which the other two branches are subject to. The whole entire point behind the Supreme Court justices not being elected meant that they didn't have benefactors and constituents to answer to, and so they could be truly independent. We've unfortunately seen that perturbed quite a bit, whether it's through dark money or the shadow docket or whatever it may be. But I personally don't think we've gone too far from that. And again, a code of conduct would help bring us back to that center ideal of why that they originally were given life tenure, so long as they served with good behavior.
You mentioned in your talk that various of the recusal problems that have come up, in particular, the one with Justice Thomas and his wife. And I was just wondering, it looks like a major defense being asserted by ex-President Trump to the recent indictment is that the alternative electors scheme was somehow within the bounds of legal propriety. And it seems like there's a good chance that that would come before the Supreme Court. And given that his wife was involved in some way with the overall attempt to have alternative electors in swing states, what are Justice Thomas's obligations to recuse himself under current law, and would the SCERT Act help out in that case, do you think?
Yeah, under current law, you could argue either way. Really, it's just whether or not his impartiality might reasonably be questioned. So it's a reasonable person standard. I think in this case, enough has come to light that a reasonable person could question. So it doesn't really matter if he would actually be influenced or not by his wife's participation or lack thereof in that case. It's the fact that so I think that section 28,455, which is the disqualification statute as it currently stands, would require his recusal. SCERT Act would strengthen that. I don't know that it would add anything specific that would do it in that case, just because under the plain word of the statute as it stands, he should recuse. That being said, there are several different situations that you might be able to, but I think we just need more facts as it pertains to Ginny. But again, under just the general rule that starts that entire recusal statute, I believe that he would have a duty to recuse.
Great. So Robin Kitson from Raleigh asks, given that Congress right now, or at least the House certainly, is controlled by the GOP and with the filibuster rule, effectively the Senate, and if we can't get anything through, like the SCERT Act, what's the strategy for people who are concerned about this? Wait until after 2024, go with a minimum of getting an inspector general. What can we do now to deal with this problem?
I would say yes, and first and foremost, vote and get people out to vote, because 2024 will be the consequential year when, well, in reality, 2025. But when you can get robust reforms done, assuming we're able. Keep in mind, CREW is a nonpartisan organization. So when I say we, I'm speaking personally for Democrats. But when Democrats will hopefully take both houses and hopefully the presidency. Short of that, currently, I don't think it's all lost. It's just going to require a lot of on the ground work. And again, that means contacting your senators specifically because they have the ability to move that legislation now, and talking to those on the fence. You have 50, you only need 60. And they're up until recently, this was a bipartisan issue. I mean, the Supreme Court Ethics Act, which is what started this all, was first introduced in 2011 by a Republican, and a Republican sponsored it up until 2018. So it's just since this has become such a political thing, and so needing to step back and take it out of the politics. And short of a Supreme Court, liberal justice doing something as egregious as Justice Thomas, that you're not going to get it that way. So talking to your members of Congress and really explaining why this is a kitchen table issue. This is not, gas is seen as kitchen table, all those things. Like, people don't realize that this is also an issue that affects their constituents as well. So being able to talk about that, I think, so it's not all lost. Again, also in the House, there's only a 4-vote margin. And there are Republicans, Nancy Mace, she's here on the East Coast. I think she's North Carolina. She's one who's been willing to cross over on Supreme Court ethics issues. They're out there. It just is going to require a lot of on the ground work before 2024, and then 2024 is getting out the vote.
And Robin has a follow-up question, which is, do we know which of those of the 10 Republicans one would need to get progress? Which of the 10 are easiest to move on this issue?
I should probably be able to name them off the top of my head. I can't. I can email them to Pablo, but they're probably the ones you think of. They're the ones who voted to convict Trump during impeachment. There are some surprise ones. There's a senator on judiciary, I'm forgetting his name, but he previously had introduced the Inspector General bill that we're trying to revive. His name is escaping me. So he's another. So it's just getting them to listen and engage with you on the issue. The Supreme Court ethics is a niche issue that people will float in and out on when there are scandals. So this needs, if we really want to implement change, we need kind of a full body attack against it in terms of lobbying that just we haven't seen in the past 10 to 15 years.
Tim Smith has asked, what are your thoughts about the proposal to increase the size of the court by 4 members?
So I will start off by saying that CREW as an organization has not endorsed court expansion as of yet. We don't oppose it. We just have not, as an organization, decided to do that. Personally, I actually also helped draft that bill when I was with Congressman Hank Johnson. And I can say anecdotally that I was not on board originally. I was not convinced. I'm an institutionalist when it comes to the Supreme Court. I thought that, and I mean, to an extent, still do, that it would start this never-ending cycle of adding justices to the bench, undermining the court's integrity that way, making it even more political than it already is. Now, I also happened to go through 2 impeachments when I was in the House, and now I'm seeing how that's being weaponized by the Republicans. So I think that's a valid concern. But my boss at the time, whose idea this was, and he was really passionate about it after Justice Ginsburg died, so we drafted this bill and introduced it, but he convinced me otherwise by sheer numbers, to be honest. So Congress has expanded the court 7 times in the past. Thomas Jefferson added a seat to undo his predecessor's bid to steal one from him. Lincoln, Grant, and the Reconstruction era Congress changed the court size 3 times to help defeat the South. The most recent time that we changed the court, I think, was in 1869, and that set it to what it's currently at, which is 9 justices. And the reasoning for that was because we had 9 judicial circuits. So there's for each judicial circuit. So based on this, on history, the easiest and most argument in favor of expanding the court is one of expediency and caseload. We have currently 13 judicial districts. The nation is substantially larger than it was in 1869. I can attest to the fact that the 9 justices are very overworked. The cases that they hear now or that they have to review the amount has skyrocketed, and the complexity has also increased. So by adding even just 4 seats, which would make it 13, that would mean there is now a justice for each judicial circuit, which was the reasoning for it back in 1869. So that right there convinced me. There are, of course, plenty of other arguments to be made about, court packing and taking back the seat that was stolen by Mitch McConnell after Scalia died. But that right there, I think, is the best argument for those who are maybe on the fence about that issue. But again, CREW has not taken a position on this. That was my personal opinion.
Right. Dunby has had her hand up for a while. Couldn't you ask your question? Great. Go ahead.
Yeah, but my question is that, do any of these bills have teeth? Like what is going, what would keep them from ignoring these things? They're already ignoring there are some rules about reporting that are being ignored. So if there were a inspector general or some kind of consultant ombudsman person, would they at least be able to be transparent with the public to say, we advise that this case, this justice recused him or herself, and they didn't, or they did, just where is the transparency? Where are the teeth, if there are any?
It's a great question. So the Murkowski-King bill, for example, has no teeth. Well, there is some publication requirements, actually. So I take that back. There's a bit of transparency. The SCERT Act does have some teeth. I will say they could be a bit stronger, but again, it was drafted in mind as a first step. But there are certainly some transparency requirements within that, so that we would know. So for example, they would need to publicize, whether if they had a conflict, then, if they decided to recuse, or if they didn't, they need to explain why, which does not currently happen, or it's not currently required to happen. Therefore, it does not happen very often. It's happened twice in the past 10 years. So no, yes and no, I guess is what I would say. The one that has the most teeth is the one that will never pass, which is Senator Warren's bill, unfortunately. But again, the SCERT Act does have some teeth, and there's certainly quite a bit of transparency requirements in there, which is, I think, the best we're going to get right now with this Supreme Court. And that's with the publication requirement and the need to disclose more robustly than they currently have to. So, as a general rule, file their disclosures. They may be late and they may omit certain things, but it's not always black and white. Recently, it's been a bit more so, but yeah. So I mean, it's a great question, and I wish I had a better answer, but again, the SCERT Act was passed or created to keep in mind that it could potentially pass, which means pretty dull teeth, but teeth.
Dale Anderson asked, given that one of the 5 canons is they should performing fairly, impartially, and diligently, is the current increased use by the Supreme Court of its shadow docket an ethical issue in your view?
Wow. We could talk for another hour on the shadow docket. I mean, it certainly strikes at the heart of transparency, right? I mean, the shadow docket is often literally done in the midnight hours. It was meant to be an emergency docket. It is certainly not that now. So yeah, I mean, it's certainly a perverted use of an. Yeah, I wish I had a better answer. Yes, I guess would be my answer. I don't want to expand too much. So yeah, I think it is. And that certainly is something else. And there is actually a bill that is forthcoming that I just advised a member of Congress on. I can't remember who it was, but they're getting ready to introduce it. And it will get at the heart of the shadow docket, which is certainly something, because it will touch on jurisdiction that Congress can regulate.
Right.
Well, I want to thank you, Brie and David, for enlightening us and shepherding the questions. We want to respect Brie's time, and we want to respect the time of everyone on this call, including Reverend Latifah, who's going to now extinguish the chalice and close out our sacred space. But before we do that, I just want to remind everyone that you can go to our main webpage, uusj.org, and take many of the actions that we have there available to you, including one on the SCERT Act. So please feel free to take action, sound off to your members of Congress. And if you want to get more deeply involved in deciding how UUSJ engages on what issues, or even just exploring more what we do with our democracy action team, I encourage you to reach out to me and I will connect you to the members of that team. And you can join the group of Unitarian Universalists who are engaging for a healthy, inclusive democracy on behalf of UUSJ. So with that, I turn over the spotlight to Reverend Latifah.
Thank you, Pablo, and thank you all for being here this evening. Let us, before I extinguish the chalice, let us acknowledge the synergy that was present in this space this evening and in conversation. May we leave this meeting more committed to Unitarian Universalism and to social justice. Blessed be, and amen.